We're going to go ahead and get started. Welcome to the Harvard Law School Library Talk for the American Journal of Law and Equity, Volume 4. I want to thank Dean Goldberg's office for their generous support of the Faculty Book Talk series, as well as our wonderful librarians and archivists that keep this event going. Specifically today, Terry Messina, Naji Zhang, Deanna Barmakian, Debbie Ginsberg, and Maya Bergamesco for their assistance. And I also see Christine Park over there, so I'll shout her out. Before we get started, please make sure that your phone is off or at least quiet. And today we are joined by this fantastic, exciting panel: Martha Minow, Randall Kennedy, Benjamin Eidelson, and Ken Greenfield. Martha Minow is the 300th anniversary university professor of Harvard Law School, where she teaches constitutional law, fairness and privacy, and law and equality. Randall Kennedy is the Michael R. Klein Professor of Law at Harvard Law School, where he teaches courses on contracts, criminal law, and the regulation of race relations. Benjamin Eidelson is a professor of law at Harvard Law School and a scholar of public law and issues at the intersection of law and philosophy. And finally, Kent Greenfield is a professor of law and the Dean's Distinguished Scholar at Boston College Law School, where he is a scholar of constitutional law and corporate governance. So I'm going to turn it over to my panel, and we will have time for questions at the end. Thanks, everybody.
Thanks so much. I'm going to kick things off with just a couple of impressions, comments, maybe recollections, and then the rest of the folks on the panel will fill in things. First of all, I should just note, so this journal, we just published our fourth issue, and I'll just say a little bit about the beginnings of the journal. I was brought in by Martha Minow and Cass Sunstein. Got a call one day, it was during the pandemic, and they basically said, listen, the dean has, approached us. As the dean has approached, lots of people. We're very concerned. This was in the middle of the pandemic. It was also in the middle of the widespread reaction to various police killings and other atrocities in the United States, and there was a lot of upsetment about that. And the question was, well, what are we going to do about this? People are asking lots of questions. Don't we want to do what we do? Don't we want to channel this upsurge in emotion? Don't we want to channel it in a certain way? Don't we want to channel it into academic pursuits? And so we decided, okay, yeah, let's do that. Now, at this point, we didn't have a name for the journal. In fact, we didn't have a name for the journal for a long time. But we decided, well, yeah, okay, fine, let's have a journal. We just said, okay, let's have a journal. And that was it. And we just sort of went from there. One thing led to another. It was very ad hoc. And we've now put out 4 issues. One of my favorite parts of doing this has to do with the very end, right as we're about to put out the journal, right as it's about to be published. What the last thing that we do is decide on a dedication. And we decided that with the first dedication was with respect to the 3rd issue of the journal, and 2 of the editors, not 3, but 2 of the editors insisted upon a dedication. That was the beginning. And the person that we insisted that the 3rd issue be dedicated to was Newton Minow, our co-editor's father, a very distinguished person in the law who did many things in the law. But one of the things that he did, certainly in my study, one of the things that he did was throughout his time as an attorney, showed a very keen attentiveness to issues of racial equality. And so Newton Minow was the first person to be, our journal was dedicated to. In our last issue, the issue that we're celebrating today, Charles Ogletree Now, Charles Ogletree was a longtime faculty member here. And, when we were thinking about, well, who would be a good person to dedicate this to, he immediately came to mind. And we were very happy to talk about Charles Ogletree and attempt to further memorialize his name and spirit and record in this law school. Just a couple of other comments. One, right before coming over here, I took a look at our website for the American Journal of Law and Equality. And the MIT Press has a very nice thing there where it notes most read articles in the journal. And the most read article in the journal of the 4 issues is an article by Martha Minow on equality and equity. And when her turn to bat comes up in a few minutes, I want to hear more about the difference between equality and equity, in part because in recent days it's come up in our political context, our very tumultuous political context. But the difference between equality and equity has actually come up. And so I think it'd be a nice thing to hear from Professor Minow about that.
It's a cold call. Okay.
The other, I should mention, the second most read part of the journal was a symposium in the first issue on meritocracy. In our last, in all of the issues of the journal, symposia have been in a very important part. And in our last, in our most recent issue, there was a symposium on Brown versus Board of Education. Very happy about that symposium. I think it's quite distinctive, actually. I'm willing to bet that there's not another symposium on Brown versus Board of Education that has as wide an ideological spectrum of voices as this one. It's got a very wide spectrum. And then we had a symposium on affirmative action, and in fact, 2 of our panelists are going to speak to that, Professor Eidelson, Professor Greenfield. Look forward to hearing what they have to say about affirmative action. Again, an issue that, is right on our front pages, still extremely volatile. I'm going to end by noting something that I hope that our journal will turn to more in the future. And in the question and answer in this session, one of the things that we're always interested in is, what should we be attentive to for future issues? And I'm going to put something on the table right now. One of the things that I think I'd like to address more is the negative aspects of equality. So thus far in the 4 issues of our journal, we've talked a good bit about the problem of inequality, the problem of the arrogance of the winners. I'm thinking of the symposium on meritocracy. That was a very big theme. Michael Sandel in particular, the arrogance of the winners. Question I have is, well, but what about the problem of envy? What about the problem of resentment? What about the problem posed by people who perceive themselves to be losers and are willing to destroy the society because of that perception of themselves? Seems to me that that's an issue I'd like to hear more about. And that does it for me for now. Professor Minow.
hard act to follow. This has been a just real honor and a joy to be a co-editor, and I want to add my thanks to everybody who's participated in the journal, but also in this event, and to invite any student who's interested. This is a faculty-edited journal, which is an unusual phenomenon in the legal world, but students are involved, so if you have an interest, let us know. I do want to say that the ideological range, particularly in the Brown Symposium, is because of Professor Kennedy, who reached out to some people who I don't know that they would have participated, but for your reaching out to them. So, as is true in many, many aspects of the journal. You call on me to talk about this article that I did write called Equality versus Equity. I wrote it right after the election of President Biden. And one of the first acts that his administration engaged in was to issue a series of executive orders calling for equity. And I wasn't sure what that meant. So I wrote this article. I had a lot of help from Ben Eidelson, who said, "What do you mean by this? And what do you mean by that?" And the article is simply trying to map what are these different words, what are they signaling, what are they trying to accomplish. I do talk in the article about a cartoon that has been widely circulated, started in the education world to try to explain the difference between these concepts. And it shows children standing outside of a fence trying to watch a ball game. Some of you have seen it. And one of them is standing on a box and therefore tall enough to look over the fence. Another one is standing just on the ground, a middle-sized child who can see over the fence anyway. And then there's a small child who's not able to see over the fence. And equity is described as the child who's given the box to be able to look over the fence. There have been some variations on that cartoon that show a tall child who's dug into a pit and not allowed to be able to see over the fence. I mean, there are some debates about what equity means. One of the reasons that I wrote the piece, not only to try to understand these terms that I don't fully comprehend even to this day, is that I think equality has gotten a bad rap. And a lot of people dumping on equality as it's insufficient. And I just disagree with that. And a purpose of the piece is to say there's an inattention to what equality has meant, both in American law and in jurisprudence. So there it is. I did write a piece in the new journal, the new issue, which I don't think anyone is going to bump to the top. But I want to say a couple of words because it's related to Professor Kennedy's closing and challenging comments about resentment. So this is a piece that's called Justice in Divided Societies, in which I deal with the question of inequality by looking at social divisions and resentment being a big source of divisions in this country and around the world. And the main point of this piece is to both have a historical understanding that there has not been a society without divisions and hierarchies, and at the same time that there are periods in history where that's more accentuated versus not. And I begin the piece, and I thought I would just say to you, when with a memory that when I started in college, walked into someone's dorm, and there was on the wall a poster that had Henry David Thoreau's saying that if a man does not keep pace with his companions, perhaps it is because he hears a different drummer. You've heard of that, right? And then on the other wall, the other person in that room had a poster that said, "No man is an island." So on the one hand, we had a poster saying, be your own self. And the other was saying, oh, we're all connected. And I thought, this is college. This is going to be it. We're going to be living with, conflicting or contrasting views. And the contrast that I try to focus on in this article is between two injunctions that I hear regularly. And one is to speak out against injustice. And the other is to not demonize your foes. And can those two be put together? So that's the purpose of that piece. And I think it's a tough challenge. I think that it's something that I struggle with every day. You feel strongly about your views, and it is very tempting to try to treat the people on the other side as somehow less than you, or as enemies, or even as non-human. And yet we know that leads to the cycles that are terrifying in history in this country and elsewhere. So that's what I wanted to say in that piece, and I argue that it's possible to stand up against injustice and not demonize your foes. It's kind of sad to have to say that, but it feels like a necessary thing to say. And with that, let's turn to the symposium participants.
Great. Okay. So I'm very happy to have an article in the fourth issue of the American Journal of Law and Equality, together with Professor Greenfield. I'll say a little bit about mine and hand it off to him. This paper is co-authored with Deborah Hellman, who's a law professor at University of Virginia, and tries to work through questions that we both had in the wake of SFFA, Students for Fair Admissions versus Harvard. So it's a somewhat doctrinal paper in that it really is about the law and a case, but bringing to bear some philosophical concerns that we both have. And we called it Unreflective Disequilibrium, Race-Conscious Admissions After SFFA, which nobody laughed, but it's a very funny joke if you are in a very small set of moral and political philosophers. It's an allusion to this famous idea associated with John Rawls of reflective equilibrium, which is the process that he and others described of sort of how you come to reasoned, principled decisions about things, which is, on the one hand, you have certain general principles that seem to you compelling and sensible. And on the other hand, you have particular case judgments about like, well, you know, that can't be right, or that's definitely wrong, or whatever. And at first, these don't line up. Like the principles that you're drawn to don't actually fit and justify all of the particular intuitions you have of particular cases. And so you do some adjusting to each. You give up some judgments that you thought were right about particular things. On the other hand, you adjust the principle from what you thought was right to make it fit the cases that you think come out the right way. And then you end up in some kind of equilibrium, this reflective equilibrium. Okay, that's like a model of reasoned, conscientious, principled decision-making. And this seems to us to capture what the court did not do in SFFA. That's why it's unreflective disequilibrium. And the thought is, it's not just, therefore, that we think SFFA is bad or wrong in the sense of preferring the old affirmative action regime, although I think it's fair to say that's true of me, and I think I can speak for Professor Hellman to that extent. It's not just that it's bad, it's that it's in an interesting and problematic way incoherent. Like it's unwilling to do the reconciling work to square the different things that the justices in the majority think, and kind of just saying both. And that leaves the law in a kind of indeterminate place. And you see that tension come through very clearly in a part of the opinion that attracted a lot of attention when it came out, where they said towards the end, as all parties agree, nothing in this opinion should be construed as prohibiting universities from considering an applicant's discussion of how race affected his or her life, be it through discrimination, inspiration, or otherwise. And it's an interesting question, I think. What exactly that they're blessing something, right, at the same time as they're quote unquote, ending affirmative action. And so how they think both of those things can be true, sort of an interesting issue. I'll tell you one sort of odd story about this. So that line in the opinion is followed with a citation. So like see joint appendix pages, blah, blah, blah. Okay, so in doing this paper, we thought, okay, so like what are they pointing to support this statement that everyone agrees certain things are okay? And it turns out they were citing a sealed portion of the joint appendix, so no one could actually access it, which I think was a mistake. Maybe it kind of says something in itself, but so I emailed the clerk of the court and said, I think this is a mistake, and they amended the opinion. So it's the only article I've ever written that actually changed something in the U.S. reports, and so now it cites the things in the trial court that apparently they meant to cite in the first place. And it's not the parties' concessions about things, actually. It's like particular students' college essays that were admitted into evidence in the UNC case. And I take these, therefore, to be examples of this kind of stuff is okay, right? It's students basically talking in all sorts of ways about, in race-laden ways about their own experience, just like you might imagine in a college essay. Okay, so the puzzle is what exactly is still allowed by this language in SFFA. And what Professor Hellman and I did is sort of taking these examples from the record as data points, but also kind of spinning out various hypotheticals, which see if I subject you to them or not, I'm not sure. See how much time is left. Try to work through like what principle could account for the thought on the one hand that you can't consider race, but on the other hand, of course, you can consider what, like the way race mattered in people's lives, something like that. Okay, those sort of hang together if you think that race doesn't, very rarely figures in people's lives or something. It's a puzzle, I think. I'll give you one. I will give you one of the examples because it seems like there's time. So contrast these two imaginary college essays. And I'm not saying these are good as college essays, okay? That's not their function, but as just a juxtaposition. So one applicant says, my Black identity has been an important source of inspiration for me. I know that I stand on the shoulders of so many who sacrificed and fought for the opportunities that I enjoy, and I feel I owe it not only to myself, but also to them to make the most of those opportunities in my own life. Okay, that's applicant A, right? Applicant B says, my white identity has been an important source of inspiration for me. I know that I stand on the shoulders of so many who sacrificed and fought for the opportunities that I enjoy, and I feel I owe it not only to myself, but also to them to make the most of those opportunities in my own. Okay, so our thought is, to the extent that SFFA is saying, look, universities, of course you can consider like what people say about race and how it's inspired them. That's one of the court's words. Considering this in some form is allowed. Right? That language doesn't mean anything unless it means that you can afford some kind of weight to this paragraph in the essay. Okay. But I just think it can't possibly be that they think you have to treat these two essays the same. Like you have to, because they're just saying different things. I mean, one of them is saying, I'm inspired by the civil rights movement, right? University can value, being inspired by the civil rights movement. That's a good thing. And maybe they'd value that in anybody, Black or white. The other essay is not saying I'm inspired by the civil rights movement. I don't know exactly what it is saying. It's definitely not that. Okay, so we know already, right, that there are contexts where the university can be sensitive to the race that the person avows in the essay, treat them differently on account of that, because they have different significances. They tell you something different about what the person is otherwise communicating to you. Okay, so the paper, and I'll stop here and invite you to go read it for free online to get the whole story. But the thought of the paper is like, you can basically generalize that to much of what colleges conventionally have wanted out of affirmative action programs. And so because the court is sort of saying both don't consider race, but yeah, to the extent it's relevant, of course you can consider the relevant stuff. There's a lot of room for interpretation about what's allowed. And I think one thing that I hope, at least, is that even as I assume the Trump administration will announce an interpretation of SFFA through the Education Department that's maximally restrictive, I hope that universities will take seriously the open texture of that opinion and press the issue and still try to make good on the values that they have been animated by in the past, rather than kind of proactively retreating and reconciling, doing the dirty work for the administration and perhaps some people on the court of trying to square these things that are quite inconsistent. All right, with that, Professor Greenfield.
Thank you.
Yeah, thanks, Ben. In fact, that's a good transition to my talk. And again, thanks for letting me be on this panel and be in this journal. It's an honor to be among this crowd. The origin of my piece really came about when I had the good fortune, or bad fortune maybe, of being in the gallery while the court heard argument in 303 Creative about 2 years ago. 2 years ago was a big year at the court, right? It had SFFA. About a month before it heard argument in 303 Creative. 303 Creative, if you don't recall, is the case about the web designer who did not want to create websites for same-sex weddings. And the court had this long, drawn-out argument, not as long as the Harvard argument, which was a marathon argument. The 303 Creative argument went along for about 3 hours, and really, the case was about whether this for-profit company had a First Amendment right to be exempted from otherwise applicable anti-discrimination law, because they had a First Amendment interest that was being burdened by the application of state anti-discrimination law. So as I was sitting in the argument there, I'm like, why can't the universities make this very same argument when it comes to the use of race in applications? And so I've done, since that sort of light bulb went off, I've been doing a deep dive into this, and my article in this journal really sort of spells out how these two trends in sort of a conservative court doctrine, on the one part, an increasingly formalist view of race, on the one hand. On the other hand, an increasing attentiveness to First Amendment claims of institutions, individuals, companies that want to discriminate, how actually they are in conflict, and how that conflict might be used by universities that want to assert principle mission-based rationales for the continued use of race in admissions. And not only that, I should hasten to say, I didn't write this, but it's now become much more obvious why universities might have a First Amendment-based reason to resist executive orders about DEI, for example, or executive orders about anti-trans care, caring for students who are gender minorities. And the insight here that you have to start with is that in the Harvard case, you had two defendants, right? UNC, which was a public defendant subject to the Equal Protection Clause. You had Harvard. I don't know if you've heard of this place. It's a prominent university in Cambridge, and Harvard is a private university. Private universities aren't subject to the Equal Protection Clause. So, but the court just assumed that the statutory obligation under Title VI that requires universities not to discriminate goes hand in hand with the Equal Protection Clause. And of course, we understand that in a world in which the Equal Protection Clause allows for race consciousness, it might go hand in hand. But in a world in which the Equal Protection Clause requires colorblindness, you might imagine that the statute passed during the Civil Rights era might be interpreted in a different way, but the court didn't even deal with that. But the key insight for this is, my piece, is that the obligation for schools like Harvard, BC, Holy Cross, Brown, any private institution, it's a statutory obligation. A statutory obligation to not discriminate, I'll put air quotes, and according to the court, discrimination means treating everybody formally equally with regard, or to use a contested term, with regard to race. But just like 303 Creative could say, we have a right to be exempted from the statute that tells us we can't discriminate on the basis of gender, of sexual orientation, mission-driven private universities can mimic that same argument. Mission-driven universities like BC, like Holy Cross, like perhaps Harvard, Brown, others, Berea College, college I've been in touch with about the possibility of raising this claim. Berea College it was created by abolitionists, and they have a core principle of providing education that is multiracial. a colorblind Berea is a totally different university than existed before this rule. And so my argument is that the First Amendment provides a basis for private universities to contest the application of SFFA, and here's my last point before we open it up, and it releases us from this notion that diversity is the only possible basis. And we all know, for the 20 years that diversity, or more, 50 years that diversity was the touchstone that universities had to cite, it struck us a lot of us as narrow, little contestable, problematic in some ways. But if you move it from the equal protection frame to the First Amendment frame, schools can say we have a First Amendment right to choose our own community, much like the Boy Scouts had a right to choose their own community. The South Boston Parade had a right to choose who marched, just like 303 Creative has a right to choose who it speaks for. Universities have that same right to operationalize their mission through its admissions process. So it's yet another way to expand the possible ways for universities to withstand, I think, what would otherwise be a very harsh rule.
Thank you all so much for sharing your insight. We are going to move to our audience Q&A. If you have a question for our speakers, please raise your hand, and my colleague Diana or myself will come around and give you a microphone. If you're joining through Zoom, my colleague Debbie will be on hand to ask your question on your behalf.
And we are open to, of course, comments or questions based on what people have said here, but also ideas for future issues, future symposia.
Thanks so much for this. And Professor Eidelson, wondering, in thinking about the tension that you described, my assumption, not having yet read your article, was that what the court was saying, if we take them seriously there, is university may have race-neutral criteria that consider people's lived experience as someone with an identity, meaning we could say we'll give an added bump to people who have demonstrated that they have overcome obstacles. Black student says, I was the only black student in my school. I dealt with racism, low expectations, I overcame them. White student says, I was the only white student in my school, dealt with expectations about me, about privilege, was bullied, whatever. We can consider both of those in the same way. And that the example that you described, the answer might be no, we can't consider either of those because they are just about, I'm proud of my identity, which is not an attribute. So would love to hear your thinking about that, and we'll definitely read the article.
Great. It's a great question. I actually am optimistic you will think that the article, whether it persuades you or not, I think it's addressed to exactly that issue. So let me bracket the part about whether, in the example I gave a moment ago, that would be illicit or not. I think it would be, but I don't want to waste time on it. In the case that you gave, I think I'm with you in thinking what they think is, well, you can consider grit, and some people get grit one way and some people get it another way, and sometimes that mechanism includes race. We don't care about the mechanism. You just got to be an even-handed grit valuer, Okay, I think that's what they think. I don't think that actually works so well because, like in your illustrations, you need to, whether formally or intuitively, quantify how much grit is shown by this particular story as told by this particular person, right? So the person who says, I was the only black student in my AP classes, and every time I was going to raise my hand, I had this wave of anxiety about confirming all the worst stereotypes about people like me. And I'll always be proud of, this is how I feel like these essays always end. I'll always be proud of the grit that this engendered in me or something. Okay. Okay. And then you said, imagine I wrote that. And I said, I was the only Jewish student in my suburban high school AP math class. And every time I was going to speak, I was worried I was going to confirm all the worst. It just doesn't entirely make sense. Like, it's not impossible to have such an experience, but there are a lot of questions about what was going on in this classroom such that I had this wave of anxiety. When I say the worst stereotypes about people like me, how would my comment in a math class put me at risk of confirming? Like, it just doesn't, it's a totally different story. And so my thought is, any coherent scheme of valuing grit, let's say, is going to, we don't have all the information, but estimate different quantities of grit in these different, as revealed in these different stories. And once you're doing that, there are questions about like how granular does the story have to be and so on. But it doesn't seem to me different in kind than saying, well, people who tell us this thing about them probably had this sort of experience, and people who tell us this probably had that sort of experience. And it's just on a spectrum at best from the kind of regime that they, at the same time, purport to be condemning. So something like that.
What's wrong with this reading of the affirmative action case? That what the Chief Justice was saying was, we're gonna make a difference here. We're gonna distinguish here between taking race into account wholesale versus retail. So in any particular case, if somebody says that race made a difference in their life that is pertinent to a decision as to their merit or what they can contribute to the school, in any individual case, fine. And so long as it's individualized, and this is part of, evaluating, Janie or John, fine. And if it's racial, that's okay. What we're saying we don't want, however, is race to be considered wholesale. So percentages are out. We don't want anybody asking how many of anything, how many of, blacks, whatever, Asian Americans, Hispanic Americans, Native Americans, the percentages are out, but individual assessment is okay.
That's Grutter, right? That's what Grutter allowed.
Yeah.
I mean, I hear you, and it does seem like that there are moments in the opinion where the chief is saying something like Grutter, but if you take Grutter honestly, they would have allowed the kinds of considerations that you just outlined, right? Because individualized consideration is what was permissible.
Yeah, but isn't it also the case that in the aftermath of Grutter, the detractors of affirmative action were saying actually that the institutions were not doing what they were saying they were doing. The institutions were saying that they're doing individualized, but everybody knows that they had percentages in mind, and we don't want that.
I think you're both right, and of course, Grutter was decided the same day as Gratz. Gratz was the undergraduate, and Grutter was the law school, and it's the difference of scale. What can you do when you have an undergraduate student body of 18,000, which University of Michigan has, that's going to be individualized and going to be more than check the box? That's a major problem. And so the regime that emerged was really distinguishing the small liberal arts colleges from the big state universities. And that was an untenable situation. I guess similar, though, to Randy's point, and I asked this to you, Professor Eidelson, I think that the difference is in part, there is a philosophic problem maybe you can sort out, that the majority seems to think that you can think about individuals without using categories.
Right.
And that you can think about individuals as individuals that somehow doesn't translate into their membership in groups. That's the incoherence that seems to me most troubling.
I completely agree with that. And if you want to read another paper, a paper called Treating People as Individuals, that's sort of it takes me a lot more words to say a version of what Professor Minow is saying. That's just how we understand people as individuals, is the concatenation of the various properties that they have. And so the idea of like, well, you can like peer into the, I don't know, like atomic like soul of this one person, and you'll have some thought about them, as if what you're doing isn't noticing things about them that fall under broader descriptions whose tendencies you think you understand. That's just like what thinking is. So I think the answer I would give to Professor Kennedy's question is in that same vein, that the individual, retail, wholesale, like when you drill down on it, I'm not sure that it means anything.
It's a very majoritarian kind of view, racially majoritarian kind of perspective, right? It's like, if you are a racial minority or a sexual minority, like it's hard to just go through life and not have that be something that you pay attention to a lot. But if you're a majority, it's the color water. I mean, to borrow a phrase.
Professor,
Trying to get someone else in, but
yes, we have somebody. Yes.
Well, I didn't want
Go ahead.
to interrupt your interesting comment, I'm sure. I guess I had two questions / observations. The first, in response to this direct line of conversation, I feel like I had heard a lot of conversation after SFFA was decided about sort of the difference of conceptualizing race as all these different things as proxies for race versus as race being a proxy for other things, and sort of part to the category discussion. Are these categories sort of means to an end of understanding someone, or are they ends in themselves? That was more the observation. The question I have for Professor Greenfield is sort of how you would address sort of like the Bob Jones question in your argument. I mean, I think to me, I would be very hesitant to go down the exemption category because, granted, that's a religious question, sort of more of a religious exemption case, but it worries me that's sort of not the direction I would want to go in. And I actually had the privilege of sitting in on the announcement for SFFA, so I was also there that term, but I was not thinking about it in combination with, I guess I can't remember if 303 was the same term, but I was thinking about it in combination with Milligan, and how Milligan seems to suggest there's this way to thread the line between racial classifications and other things.
Yes,
So,
really smart point. And I do a deep dive about Bob Jones and Runyon in the article. So I wrestle with this, and you raise an excellent sort of way to cabin or question my perspective, which is: are we opening a Pandora's box if you allow people to claim First Amendment rights to discriminate, not just on the grounds of sexual orientation, which have been the cases so far? Boy Scouts, Hurley, 303 Creative, but also open up the possibility of people discriminating on the basis of race. This was brought up in the oral argument in 303. You know, that you may have a vague memory of the Justice Ketanji Brown Jackson's hypothetical about the mall Santa during the holidays, and the way I deal with it is, I think, in all honesty, I think the Pandora's box is already open, and we might as well use it to our benefit. And especially if you read Gorsuch's opinion in 303 Creative, he doesn't even do the strict scrutiny stuff at the end. He admits that the state of Colorado has a compelling interest to fight discrimination, but he says but the First Amendment always wins, even in the face of a compelling interest, that's not the way I teach my students strict scrutiny. But I think there's a move to have super duper scrutiny when it comes to these things. And if we're in that world, I think it's a mistake for us to keep this tool in our toolbox and not use it.
I hate to interrupt. This is an amazing discussion. If we could give our speakers another thank you for all coming today. Thank you all as well, audience members. Our next book talk will be next Wednesday, February 19th, in the same room at 12:30 for Climate Justice: What Rich Nations Owe the World and the Future by Cass Sunstein. Please help yourself to lunch. There are plenty left. And thank you all again for coming. Have a great rest of your day.
I know, right? Thank you.